Welcome back. This is a new program on AM 650. It's You and the Law. I'm Sterling Fox, joined in studio by lawyers Joe Murphy and Scott Stanley from Murphy Batista in Vancouver. Gentlemen, just before we took the break, you're personal injury lawyers who deal exclusively in that area and insurance law. It's all part of the same package. We were talking to Joe about small children when you represent the child in a case. The court system, the whole system, treats children very, very differently than adults in personal injury cases. Why is that?
Sterling, I think the background philosophy is this. When you drive a 3,000 or 4,000 pound car down the road, you've got to be careful. And the law recognizes that small children, 2, 3, 4, 5, 6, 7, 8, up to 10, 11, 12, don't have good judgment. They don't have any experience. Mm-hmm. So it's not uncommon for a child to dash out onto the road, into the path of a car, or one case I did where two girls ran into the side of a passing car, where the courts say to the motorist, you saw these children, you knew they were there, you should have known they were there, and it's your fault that this accident happened. So it's not uncommon for parents to contact me and say, well, our child was terribly injured, but the motorist didn't do anything wrong. And when you look into it, you find that because there's these special rules for children, and because drivers of cars capable of doing great harm have to be very careful around children, that there is, in fact, a legal responsibility on the motorist.
Scott, do most British Columbia drivers know this? I'm a driver. I've been licensed in British Columbia since the 70s. I mean, I appreciate playgrounds and school grounds and slow down and all of that stuff, but do most BC drivers know that the courts are always prepared to make an exception in the case of a child?
I don't think they do. I would say the vast majority of drivers don't appreciate that. I would like to think most of them would. If they saw a pot of kids beetling around,
you back off, of course.
You'd slow down and you'd back off, but it's amazing a lot of people don't.
And moms and dads, you were saying, Joe, call the office and say, my child was really badly banged up in a traffic accident, but the motorist wasn't at fault. Now, is that because the motorist got out of his or her car and said, oh my gosh, I'm so sorry, and I didn't see her until the last second, I wasn't going fast, and do that sort of thing, which you would do, I think, kind of out of a human reaction to the situation.
Sterling, the speed limit through most residential areas is 50 kilometers an hour.
Yeah.
A car traveling 50 kilometers an hour travels 43 feet in a second. And that driver to perceive and react to a hazard and stop at that speed probably needs 120 feet. So if you watch how people drive down their own street in a residential area with cars on both sides,
yeah,
they drive very slowly because they know there's kids around and they have to be careful. That's the way people should drive in neighborhoods where they know there are kids around, or they know there's likely or possibly kids around. So people get confused that a speed limit means that's a safe speed, and oftentimes it's not.
It's a maximum speed, isn't it?
It's 43 feet a second. A 3,000-pound vehicle coming down at that speed. If people look at it that way, they say, well, in a residential area with cars parked on both sides, is that safe? The answer is, of course not. And that's why when they drive down their own block, they're probably going 10 or 15 kilometers an hour, or even slower.
On your own street?
That's what a safe speed is.
You do that on everybody's street.
In everybody's street,
right,
when you can't see, when you know there's children around. And there's special rules for children because they do make mistakes.
Yeah.
Their judgment is poor. And there's a variety of cases, including children as old as 11 or 12, where the judge says, we know they did something wrong, but they're kids and kids do things wrong. This was an error in judgment, and the motorist should have taken steps to have avoided this accident.
So, Scott, as a lawyer with a child as a client in a personal injury case, is the court, or would the jury, depending on the setup, be inclined to be more sympathetic because it's a child? Is that a given? Is it an advantage to you as their legal counsel?
Well, it probably is. I mean, juries aren't supposed to make decisions because they feel badly for some person or because they like or dislike someone. They're given fairly specific instructions about what they're supposed to do. And so they probably would be sympathetic to an injured child. Who wouldn't be? but that's probably not going to determine how they decide the case. But a judge will give them very specific directions about how they're to decide the case, and one of those would be, just as Joe said, little kids make mistakes, and it's incumbent upon drivers to account for these possible mistakes in judgment that little kids would make and to drive accordingly.
All right, let's talk about some of the other cases, those not involving children, but those involving people in car accidents who get injured. And let's sort of run through some of the typical reactions people have when they're involved in a traffic accident in which one or more individuals suffer some measure of personal injury. And I guess the first thing we all want to know is, well, what's the first step? If you've actually been hurt in a car accident, if let's assume that you didn't have to be taken from the scene to a hospital in an ambulance, what do you do? What's your first step?
Well, the first thing they have to do is they should, if they're right at the scene of the accident, they should make sure they get the information from the other driver.
Okay,
they should
right.
get witnesses.
Right.
Our firm actually has an app that allows people to do that right at the scene, which is kind of a neat little tool for clients. And then after that, you got to report it to ICBC, because you've got to do that to get a claim started, and they'll typically want to schedule you for an appointment to come in and see them. You should talk to a lawyer before you go to that appointment.
You can schedule the appointment, you don't need a lawyer. But before you sit down with anybody from ICBC, you should sit down with a lawyer first?
Well, you should just phone them.
Phone them.
Okay.
Yeah, phone them. And it may be appropriate for you to go to that meeting. It may not be. But you should talk to a lawyer first before you go to that appointment. And, because, people may not need a lawyer, but they should talk to one. And that'll have to happen. And then the other thing is, if you haven't sought medical attention right away, some people, a lot of times with minor injuries, they don't show up until a day or two afterwards. Got to go see your doctor or see a doctor and make sure these things are documented. So get information at the scene, report it to ICBC, talk to a lawyer, and then go see your doctor. Those are the four things that people need to do immediately, within, say, a day or two after the accident.
Okay, now you said that it may not be a particularly good idea to go to that meeting with the ICBC adjuster that they usually request. Why wouldn't it be an advantageous thing to do?
Well, give you an example. Say a client's been in an accident where they sustained a concussion, a brain injury. And in order to prove a concussion, you have to establish that the client had a gap in their memory or they were confused. And when you go to ICBC, they'll have you fill in one of these statements, and they're not going to ask you to tell them what you recall. They're going to ask you to tell them what happened. And so people will set things out as though they had a continuous memory after the accident when in fact they didn't. And in fact, Joe and I about 4 years ago did a case where a lady had an obvious brain injury, and they were defending it on the basis of her ICBC statement. And this lady was an investigator, and so naturally, when she didn't know something, she just deduced what happened and put together the statement that made it look like she had a continuous memory. And they, of course, were saying she had no brain injury because she had a continuous memory.
Look at this articulate statement.
With incredible detail in her statement, which her husband helped her do. And that was a big part of the defense of that case.
So they said that this woman isn't injured. Look at this comprehensive, clear assessment of what happened.
There's no gap in her memory. It was finite details in the statement.
And you had to, in some way, disprove that allegation that she was just fine. So what did you do?
Well, we called the husband, who himself was an investigator, and basically had him confirm that he was the one that helped her put the statement together. We did 5 or 6 days of that trial, and then ICBC paid all the money. They realized
policy limits.
Yeah,
interesting. How long typically would a case that doesn't involve massive personal injury, but there's some degree involved, typically how long would that process take before you get your check or whatever from ICBC?
Well, I guess it really depends. For us, we're not going to settle a claim or have a client look to settle a claim until we know what the injuries are and to what level they've resolved. As soon as a client's made a good recovery or full recovery and the doctor agrees with that, you can move to settle their claim right away, and that can be sort of 6 to 8 months. If you have one of those minor injuries, I'm of the view that you probably don't need a lawyer. You can probably deal with ICBC on your own. Cases that we handle more significant, we're not wanting to look at settling the claim until at least 2 years. That's typically when the doctors are able to tell us what the level of recovery is and what it's likely to be in the future.
Okay, it takes 2 years of assessment and development for something to be strongly indicated that this is the way it's likely to carry on.
The expression I use, Sterling, is when the dust settles.
Okay.
When you can see what you've got. And oftentimes, or sometimes, doctors will say, well, this is where this patient is, and if they take this treatment, here's where they'll end up. And our attitude is, well, let's have them take that treatment. Let's find out what the results are, and we'll find out if it turns out well, good for them. If it turns out poorly, we know that. So, as I say, it's when the dust settles. And with children, it takes a long time for the dust to settle. With other cases, it's different, but each case is unique.
If you are injured in an accident, Scott, and you advance a claim, and does ICBC have the right to go into your personal medical history? Can they get as nosy as they feel like because you've made a claim on your policy?
Well, they can't get as nosy as they'd like, right? But they're definitely entitled to look into your medical history.
Really?
Yep.
Can they just call your doctor's office and say, well, you know, one of your patients has filed a claim, so send over the file?
Well, if you're dealing with ICBC on your own, that's typically what they'll do. Your doctor has to provide them with a short little medical report. They have to provide that. If you've also provided an authorization, then yeah, they can get your medical history as far back as they want.
Okay.
They typically show some restraint. They generally look at it for a period of maybe 2 years before the accident, which is sort of where we want to. I mean, if we have a client, we want to know what the medical history is as well. So I think, you know, a period of a year or two is a fair game to see what's in the medical history. But
Sterling, one of the things I want to explain is when these people meet ICBC for the first time after the accident, one of the documents the adjuster will give them and say, you need to sign this, is a blanket authorization for all their past medical records.
Okay.
Now, our clients don't sign those documents.
I was just going to say, are you required to?
No, but the adjuster will tell you that it's needed to process the claim. So
and make you feel bad, like you're committing some kind of error.
Well, you're hiding something if you won't
okay.
give it to them.
And so they make you feel bad. Well, what are you hiding here?
Yeah, so if we get hired after that's happened, we have to revoke all those authorizations because they'll be used by ICBC to dig up whatever they can to be used to defend the claim.
Right.
And it's not necessary. Once a lawsuit started, ICBC, under the rules of court, has access to relevant medical records. But before then, they rely on this document that most people think they have to sign when they meet with the adjuster.
Okay, now we need to take a break. So and this is a good point to do it because now you just mentioned a lawsuit, and up until this point, I've been talking about a claim. So let's find out, we'll take a quick break here, and we'll find out how or when a claim becomes a lawsuit. Personal injury lawyers Joe Murphy and Scott Stanley from Murphy Batista, LLP. The website, by the way, friends, is murphybatista.com. This is You and the Law on AM 650, and we'll be right back.